All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near. Give attention, and you shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, the Supreme Court of Florida, please be seated.
Good morning. Welcome to the Florida Supreme Court. The first case on today's docket is in re amendments to Florida Family Law Rule of Procedure 12.510. So we have a certain lack of adversity of interest here this morning. Counsel, please proceed.
Thank you, Chief Justice Kennedy. May it please the court. My name is Corey Branfon. I'm my colleague, Ashley Taylor, the current chair of the committee. I am the committee's immediate past chair, its liaison to the Rules of General Practice and Judicial Administration Committee, and a member of its Summary Judgment Subcommittee, among others. Ms. Taylor and I will be dividing our presentation here this morning. I will be presenting the committee's majority position, and she will be presenting the committee's minority position with regards to Rule 12.510, governing summary judgment. By a vote of 17-4-2, the committee respectfully does not recommend the continued adoption of a modified version of Rule 56 within Rule 12.510. The committee's position is that the Rule 12.510 that previously existed, although imperfect, was not broken in family court and therefore does not require fixing. It facilitated the appropriate, limited use of summary judgment in family court. Even if intended as a clarification of the existing standard, the committee believes that this court's two opinions, its April 29th, 2021 opinion regarding Rule 1.510 and its July 8th, 2021 opinion regarding Rule 12.510, send the signal to the bench and the bar that summary judgment should be applied for and granted more expansively in family court.
Let me ask you this question, because I presided in the family division when I was a trial judge, and I presided over other divisions, all other divisions in circuit court, and it seemed like family was uniquely different, I guess, so to speak. The particular area that concerns me about this whole business of summary judgment is the area of child custody, where judges are required to evaluate and weigh the factors, statutory factors, in determining who gets custody of the children. And it concerns me that that is a very factually intensive area of matrimonial law, very emotionally charged. You don't see that in other divisions where both mom and dad are fighting over who gets to have primary custody of the children. And typically it's resolved in a trial because it's something that parties usually fight about. Here, under the new rule that the court has adopted, basically 20 days after the filing of documents, a person can walk in and just file a motion for summary judgment. And how in that particular area specifically, put aside the division of matrimonial assets and liabilities, put aside all these other things, alimony, who gets the house, who gets the pot, who gets the pan. When looking strictly at what concerns me the most is the area of child custody, visitation, those type of things, where children, their future, their lives are at stake at this moment.
Thank you, Your Honor. I think that's an important question, and the committee certainly shares your concern. When Ms. Taylor gives her presentation, she will present the committee's proposal that time-sharing issues and parental responsibility issues be specifically carved out from the rule. Present precedential case law holds that parenting decisions should not be decided by default. And so certainly the committee would suggest that that be extended to what may be considered technical default, especially among self-represented litigants, for a failure to comply with the intricacies of the revised rule. Family court judges have an independent obligation to confirm that parenting plans and parenting decisions, time-sharing schedules are in the best interest of the child.
Doesn't that existence of an obligation solve the problem? I mean, isn't the fact that the judge can deny the motion for summary judgment somewhat missing from your analysis? I mean, if there's, let's say discovery hasn't closed, as we might expect, 20 days after the complaint has been filed, discovery is still open, a party moves for summary judgment. Obviously, the correct legal answer, subject to reversal if the judge doesn't do it, is to say, there are issues of material fact. I'm not granting summary judgment. Discovery hasn't closed. Subject to your renewal of the motion at the conclusion of discovery, your motion is denied. Given the judge's obligation to do that right, why should we have the fear that you are discussing?
Thank you, Your Honor. Well, I think it's missing from that specific portion of my analysis, but not our broader analysis. We have concerns with increased applications generally, including in the context of parenting issues. As Justice Labarga pointed out, these are highly fact-intensive inquiries, not just in the area of parenting, but as I'll point out, as it relates to equitable distribution and alimony as well.
Your concern is with additional filings?
Well, yes. In my personal experience, and I think this anecdotally is reflective of the experience of many committee members, many of our family court judges are facing significant backlogs already. And since family court cases are resolved by bench trial and the judges are triers of fact, they obviously maintain very busy calendars, as do their brethren in civil courts, but they're also expected to find time to write judgments, lengthy judgments and orders. And so,
I guess I don't understand why the order has to be any longer than I just said. If the judge just says discovery has not yet closed, therefore there are genuine issues of material fact that may exist, motion denied.
in that specific instance, Your Honor, if it is as simple as discovery not being closed, I agree it would not require the same degree of time. However, if you are asking a trial judge to review voluminous summary judgment evidence and try to make those determinations in the context of parenting decisions, I think it would be a significantly more time-intensive inquiry. And if they're being denied, I don't believe it's a productive use of the trial court's time, where they could be hearing other motions regarding parenting and temporary relief motions, for instance.
But counsel, it sounds like when you're talking about all of this material and evidence and things they're looking at and weighing parenting, I mean, those are material facts in dispute. I mean, a glance at that would say this is cannot be decided as a matter of law, denied. I mean, summary judgment has been around in family law, before now. It's very rarely used because it is so fact intensive. So how is this change going to cause that level of catastrophe for the family law?
So I think the signal has been sent to the bench and the bar that the court is interested in this being used more, not just in civil, but in family courts. Anecdotally, it's being something that's discussed among the bar. So again, I think you're going to see increased applications. And as I would get to later in my presentation, self-represented litigants are especially vulnerable to not responding properly. And this does give courts discretion to grant summary judgment for essentially technical failure to comply with the rule.
Wouldn't that be true under the current rule?
Yes, it would, Your Honor. But again,
I mean, it seems like the arguments that you're making are arguments against any summary judgment rule in the family law context.
And certainly I expected that question. So it is hardly used now. And so
Right.
I keep going back
So
to...
why do you think it would be used? I mean, it's fear that it would be used in the future in cases that are not proper for summary judgment, right?
Well, I think whether it's proper for summary judgment on an individual basis is going to be a determination for the trial judge in that case.
But I mean, you can look at the universe of cases, and I could agree with you that most of the cases we're talking about, best interest of the child custody issues, I mean, all of those things are not going to be proper for summary judgment. So I don't know why you would anticipate that folks would be filing motions just because we have what I view as a more sensible standard.
And I certainly understand this court's position. My response to that would be, again, anecdotally, there is discussion among attorneys attempting to use these more. Obviously, the evidentiary burden for defeating them has been raised. I think in this court's April 29th opinion, and I'm paraphrasing, it says that it'll no longer be sufficient to cite merely any competent evidence to establish a dispute. And then, as I would get to later, the Commission on Access to Civil Justice study from March 2020 shows us that 60% of our cases involve a self-represented litigant. So you do have a substantial risk when they're being filed more of more technical failures.
Let me go back to the point that was raised earlier, because what's going to happen is as soon as the 20-day period expires, somebody's going to file a motion for custody. It's going to a motion for summary judgment on custody. That's just the way it is. The suggestion is, well, why don't you just deny it because there's more discovery to be done? But the problem is it defeats the whole purpose of why we, this court, amended the rules of civil procedure to bring it more in line with the federal. And there we said the Florida and federal rules of civil procedure share the same overarching purpose, quote, to secure the just, speedy, and inexpensive determination of every action. So if we're going to say too early for this motion, come back later, well, it's not going to be ripe, really, until the day before trial, so why have this order to begin with?
I agree with Your Honor. I do think in those many instances it could be counterproductive. And more to your point, I believe that, and the committee believes that the rationale underlying this court's April 29th opinion in the civil rules do not apply in equal force to family law. For instance, the benefit of avoiding impaneling a jury. In the context of family court cases, which are obviously resolved by bench trial, it's not a question of whether you get before a jury or not. It's a question of when you get before the judge and in what manner. Similarly, the decades of federal case law, Celotex and others that this court has cited, talk about essential elements. We don't have them in family court. And family court cases are governed by state law and statute. And so you're not going to have corresponding causes of action in federal courts and be able to analogize the material elements. So those are two things that were cited by this court as main reasons for its adoption for the standard in civil court. And of course, we infer the other main point is to just generally make it more available, make it used more commonly. And I have a few other important reasons why I think that it doesn't work in family law in the same way. And whether it's granted for technical failure of the many self-represented litigants to respond, or whether it's denied because discovery isn't closed or they're multifactorial decision-making processes, it's not productive. So
Counsel, is the committee more concerned? It doesn't sound like the committee is concerned about two self-represented litigants going against each other because arguably they're not going to use this.
Right.
And it doesn't sound like you're concerned about two attorneys. It sounds like what you're mostly concerned about is when one side is represented and one side is unrepresented.
That's correct, Your Honor. And so we understand, this is my 5th year on the committee, I understand as a practice we don't make textual distinctions in the rules between self-represented litigants and represented parties. You know, there is precedent at Supreme Court of the United States in Haynes v. Kerner, that's 404 U.S. 519, a 1972 case, distinguishing between self-represented litigants and represented parties in how you construe pleadings. And so the filings of self-represented litigants are held to a less stringent standard. And so if that's not faithfully executed in this state by our judges, there's a chance that...
Practically speaking, though, counsel, I mean, that seems to be how trial judges... I mean, in my practice, I practiced family law. I mean, trial judges are very careful in this state to ensure, especially when you have represented and unrepresented, to ensure that all parties are treated equally, that it's a fair and just process. So it sounds like you're concerned about the trial judge's application of this in an unfair manner. And is that something that the committee thinks is happening? Is it going to happen? I mean, I'm just trying to understand what the concern is.
You use the term unfair, and I think you touch on something important. Our courts are courts of equity. And I obviously can't, I agree that judges, by and large, try to dutifully and faithfully execute their duties and ensure that equity is done. Although summary judgment may be an integral part of the procedure in federal court, and now in this state, again, as this court cites in its April opinion, I wouldn't suggest that it is synonymous with the concept of equity. You are not necessarily getting your full day in court. Self-represented litigants especially are being held to to respond to an intricate rule under a burden far more than that imposed in connection with a default. To avoid a default, you get a summons. You have to respond. You have to admit or deny allegations in a numbered form. It's not that hard. To avoid this, you have to get the motion. You have to understand what's being served on you. You have to know there's a rule. You have to understand the rule. You have to be able to identify what a material fact is. You have to be able to identify the corresponding evidence. And now, most importantly, under this standard, you have to be able to contextualize it sufficiently for the court. And yes, I hope that every trial judge will dutifully analyze these situations and try to ensure, even under those circumstances, that equity is done. But do I have concerns, especially when they're facing, in many instances, months-long backlogs? This rule gives them significant discretion. And I think they'll do their best, but I think if summary disposition is used widely in family court, there is the risk that inadvertently the confidence in the judiciary will be eroded among self-represented litigants and the community at large who rely on their day in court and sometimes fumbling through the evidence to try to get their point across. So with that, I see that my time is up. I thank the court for its time, and I yield to Ms. Taylor. Thank you.
Thank you, Justice Kennedy, and may it please the court. My name is Ashley Taylor, and I am the current chair of the Rules Committee. I am here today to express the minority position of the Rules Committee. As Mr. Branfun expressed, that while the committee does not believe that the rule should stand, we do believe that if the rule stands, there should be certain amendments to the rule to address.
That's not really a minority position, because you're still opposing the rule, correct? You're just saying, well, if the rule stays, you're going to, we'd prefer that you adopt these changes to it.
Yes, Your Honor.
I mean, the other part of the committee doesn't disagree with that, do they?
No, Your Honor. The committee feels that if...
It's an odd way to describe it as a minority position.
Yes, Your Honor. Understood. The committee feels that there are certain unique aspects of family law that should have the rule be tailored to these aspects. These are cases that involve, for example, people going through divorces or issues with their children. The committee recommends certain specific necessary changes throughout the rule. These modifications can be explained as resting on 4 unique aspects of family law. 1, as we previously discussed, is children's issues. 2 is the fact that there's mandatory disclosure in family law cases. 3 is that there is a large number of pro se litigants in family law cases, which is around 60%. And 4 is the fact that family law is a court of equity. So the committee's first proposed change relates to children's issues. We believe that in cases involving children, there should be a carve out to the rule. And specifically, we are stating that we want a sentence, we are asking for a sentence that summary judgment may be sought to address the issue of paternity, but may not be sought to resolve the other issues relating to children, including time sharing and parental responsibility. The reason for this is that in making determinations relating to children's issues, the court must make a best interest determination. This determination requires considering certain factors that require testimony and evidence, and the committee feels that summary judgment is just not the proper tool to accomplish that. So we do ask for this carve-out.
Never be the proper tool? It can never be the proper tool. That's the committee's position.
That is our position, Your Honor.
So let's imagine a parent who disappears, absconds.
Yes, Your Honor.
Let's say we're able to establish that other parent has left the United States, and all we know is that the parent is in some other jurisdiction, doesn't want to come back. There's no way that summary judgment could be appropriate to resolve that conflict. Help me understand why it can never be appropriate.
Your Honor, in that case, I believe the court still would have to make a best interest finding, and I believe the court needs to address the parent to find out the factors to meet that finding, and that would require a hearing to do so.
Perfect. So if the court must nonetheless make those factual findings, isn't it true that this sort of fear that's being expressed that there will be a ruling on summary judgment really vaporizes, because a motion, even under the facts I just gave you, would never lie, right? So the court will deny summary judgment. Help me understand what the problem is. It seems to me there's no skin off the court's nose to just say, okay, I read the rule, summary judgment's not appropriate. I don't need to be told that summary judgment's not appropriate. I can apply the standard, motion denied.
That's a good point, Your Honor. And the reason the committee is asking for this carve-out is to just prohibit having these motions filed. So if it's never going to be used, we think that putting in the text of the rule that it can't be used.
I guess that seems to me a very thin read. I don't know. Can you direct me to another time we've said that a rule should be changed to prevent the court from hearing argument from parties? I mean, as a general rule, we ascribe to parties a rationality in their self-interest, so we don't expect parties to be making motions that are against their interests and that will be deemed frivolous. Nor do we ascribe to judges an irrationality or a laziness that they're going to just sort of do the wrong thing under the law. I guess that's the part that really sort of grates on me, is this idea that, you know, we're expecting our judges in the state of Florida to do something procedurally improper under your view of the world, which, by the way, we would have a chance to reverse, right?
Your Honor, I don't believe it's that we are concerned about the judges doing something improper. I think it's the fact that judges would have to deal with these motions at all. If the fact that it would never apply, if we carve it out from the rule, they don't even have to have it in front of them. They don't even have to spend the time dealing with it because practitioners cannot file the motion to begin with if it's carved out from the rule. The other area that the committee would like to have a carve out is the fact that we have mandatory disclosure, which is very unique to family law. In family law courts, 45 days from service of the initial action, you must exchange for certain financial information. In the way that the rule is written currently, this motion may be brought 20 days from commencement of the action. So, for example, if a party files a motion for summary judgment, the responding party may see a material fact, but not
the 20-day period is in the existing rule. Prior to the adoption of the new rule. The previously existing rule.
It is, Your Honor. And to be candid, the committee.
So that wasn't a problem, was it?
The rule has been used very sparingly as it currently stands. So we've identified this rule during our analysis. And to be candid, if the old rule, if you will, stands, the committee does intend on going to address that issue because we've identified this and we do think that this is an issue that does not match with our mandatory disclosure requirement. And so the committee is asking that we revise the rule to match with this requirement so that a motion for summary judgment not be filed until 45 days following the initial proceeding. The third area that we feel has requested changes relates to the large number of self-represented litigants in family law cases. Now, we have certain verbiage that we've put throughout the rule that we think makes the rule clearer for litigants, but one of the main proposals we have is under subsection A. Now, the committee under subsection A believes that it would be important to put a party on notice not just of their duty to respond to the motion, but the fact that they need to provide a factual position in that response. For example, we already have in a petition for relocation this kind of language where there is a similarly serious result if a party doesn't respond. So the committee believes that because of the finality of summary judgment in a family law context, this language creates an extra layer of protection to put parties on notice of what their duty is when this kind of motion is filed. And this ties into the recommended changes in subsections D, E, F, and G of the rule that the committee feels that there should be a hearing when there is a motion for summary judgment that is to be decided. Now, having a motion for summary judgment decided runs the risk that's akin to a default judgment being entered. The difference with a default judgment is you have personal service. We don't have personal service with a summary judgment. So the committee feels that having a hearing gives the court the opportunity to have parties be heard on this issue so that their case is not adjudicated by a procedural failure to respond. And for the parties who do receive and review the motion, they potentially lose the opportunity to explain to the court through testimony their position. And as we've mentioned, these may be parties going through divorce. These may be parties determining issues with their children. We believe that the proper method to determine this is through testimony in front of the court in order for them to have that access to the court system. The final difference that is unique to family law is that it's a court of equity. We have under certain statutes, for example, Statute 6108, which is alimony, Statute 61075, which is equitable distribution, the court must consider any factor necessary to do justice and equity between the parties. In order to present any and all testimony to do justice and equity before the parties, the We believe that the court should be hearing these parties so that they can hear the testimony, they can hear all the facts at issue, and in order to use their equitable powers, a hearing would accomplish that. So on behalf of the Family Law Rules Committee, I thank you for the opportunity to be heard today. If you have any questions, I'm glad to answer them. Also, if there's anything that Mr. Branfin or I stated today that you would like clarification on, we are more than happy to submit a written memorandum. Thank you.
The only question I have is, it seems like all of the changes that you're proposing are changes that if you thought about it, you would have proposed for the current summary judgment rule. Is that correct?
I think that's a fair statement, Your Honor.
Okay.
Yes.
All right, well, we thank you both for your arguments in this case today. And the court will now proceed to take up the second case on today's docket, Duke Energy Florida LLC versus Clark.
Good morning. May it please the court. I'm Daniel Nordby from Schutz & Bowen, and along with my colleague Alyssa Corey, I represent Duke Energy Florida in this proceeding. I'd like to reserve 5 minutes for rebuttal. In 2009, Duke Energy placed a combined cycle power plant into commercial service in Bartow, Florida. This case involves Duke's petition to recover replacement power costs related to an unplanned outage that occurred 8 years later in February of 2017. Under the legal standard acknowledged by all parties, Duke Energy is entitled to recover its costs if it was prudent in its actions and decisions leading up to and in restoring the unit to service after the February 2017 outage. Unless the court would prefer otherwise, I'd like to address two principal reasons why the Public Service Commission's final order should be reversed. First, the administrative law judge and the PSC erred in concluding that Duke Energy was not prudent in its actions regarding the February 2017 forced outage. The legal concept of prudence is a term of art in public utility law that requires actions consistent with what a reasonable utility manager would have done in light of the conditions and circumstances that were known or that should have been known at the time the decision was made. This court has said that imprudence cannot be found based on the 2020 vision of hindsight. Here, the undisputed evidence was that Duke Energy was operating the Bartow plant prudently at the time of the February 2017 forced outage, and in fact for a period of several years preceding the 2017 forced outage.
Counsel, can we just focus on testimony of Richard Polich, which is in the record, right? I mean, you'd agree that that's there. Help me understand how you get around that being a basis that the ALJ might have prudently or judiciously relied upon, permissibly relied upon, even if you don't agree with it.
I'd be glad to. So Mr. Polich's testimony, which was the only testimony that was offered on behalf of the interveners in this case, represented a few important things. First, Mr. Polich agreed that Duke Energy had acted prudently not only during period 5 at the time of the forced outage, but in periods 2, 3, and 4 leading up to the forced outage. The only dispute, the only material factual dispute at the administrative hearing involved Duke's actions 5 to 8 years before the outage during what we've called period 1. Mr. Polich's testimony was that Duke Energy had acted imprudently during period 1 by operating the plant above a certain nameplate capacity for its generator. At the administrative hearing, Duke Energy raised two arguments in response to that. First, that Duke actually had acted prudently in period 1, that the nameplate capacity was not an operating condition, but then in the alternative, that any imprudence in period 1 did not cause the period 5 outage for which Duke Energy sought to recover.
And just so we're on the same page, the hearing officer found that Duke did act imprudently in operating the unit above the rated capacity of 420 megawatts, correct?
That's correct, Justice
And
Lawson.
you didn't contest that?
We contested that at the administrative hearing.
Right.
We filed exceptions to that at the Public Service Commission. We are not advancing that argument on appeal. We feel that it was error, but not reversible error. And it's not necessary to reverse here because of our alternative.
So would you agree that if that imprudent action factually caused the damage to the components in 2017 and the subsequent derating, that would be sufficient to deny the petition for recovery of the costs?
I would. If the period 1 imprudence caused the forced outage in period 5, that would be a basis. But there's no competent substantial evidence.
What about the expert testimony that it was the most probable culprit, that the actions before 2012 were the most probable culprit in the problems that occurred after that, and the replacement in 2012, the replacement in 2014, the 2 replacements in 2016, I think it was, and then the problem in 2017, that all of that is because of the vibration of the unit that resulted in a condition that caused that component to continue to wear out faster than it should have.
Well, Justice Lawson, and in fact, in response to Justice Curiel's question as well, Mr. Polich explicitly disclaimed any causal relationship between period 1 imprudence and the damage that occurred in period 5. And that's at page 3405 of the record.
And can I ask you, so it seems like this is the whole case, it seems, turns on the ALJ's view that once the imprudence was established for period 1, that it became your burden to disprove the causation. Because the way I read the order, which, isn't a thing of beauty by any means. I mean, paragraph 119 should be in a book for, how not to write a paragraph in these things. But basically it seems like the reasoning of the order is we have found imprudence in period 1. No one knows really what the connection was between period 1 and what happened afterward is, but because of the imprudence, it became your burden to disprove the causation, and since you didn't do that, you lose. That's the way I read the order. So do you accept the premise that it became your burden to disprove causation?
Well, I agree that Duke Energy ultimately had the burden to prove prudence in the overall proceeding. I think we did that based on the evidence.
It seems like you proved that you were prudent. It seems like what you proved was that your follow-up actions were prudent. I mean, I think that's kind of nobody challenged the prudence in periods 2 through 5. It seems like there's definitely competent substantial evidence to support the finding of imprudence for period 1, which you're not contesting now, even though you didn't start off conceding that, but now you are. So why isn't it right that it was still your burden to disprove causation? And that's not a rhetorical question.
No, so I think that the evidence shows that we, to the extent we had that burden, we did prove it based on the evidence at the hearing. So there's kind of 2 conceivable ways to link the period 1 conclusions to the period 5 outage, neither of which occurred here. One of them, for example, would be if the blades that were damaged during period 1 remained installed and ultimately malfunctioned in period 5. That would link the period 1 imprudence to period 5. Another would be if something else happened in the turbine that was the result of period 1 imprudence that manifested in period 5. But there's no record evidence of that either. The uncontested testimony of Mr. Swartz at 3077 to 3079 of the record, and the testimony of Mr. Polich, the intervener's witness at 3401 of the record, said that there was no damage to any steam turbine component other than the L0 blades that were replaced at the beginning of period 5. So if the only evidence from both of the witnesses here was that the damage was exclusively to the blades, and they were new blades installed at the beginning of period 5, and there was nothing else in the record of any evidence of damage with the steam turbine, then there's simply no causal link.
What did cause the problem in period 5?
Well, we've referred in our brief to a couple of exhibits, Exhibit 82 and Exhibit 83, which contain some confidential information that I don't want to go into here, but the Mitsubishi root cause analysis identified some problems, but they weren't the problems that the Office of Public Counsel and the other interveners identified as causing the period 1 imprudence. Their theory as to period 1 was that it was operated above nameplate capacity. The record's undisputed that it was not operated above nameplate capacity in period 5, or indeed through periods 2, 3, or 4.
So I read Pollock's testimony as saying essentially that the cumulative wear on the unit from excessive vibrations during period 1 was the most probable reason for the need to replace the blades and the continued wear on the blades throughout periods 2 through 5. If that is correct, if he said that, wouldn't that be competent substantial evidence to support the hearing officer's finding to that effect?
If he said that, I would agree. I don't think he said that. I think his testimony about cumulative wear was directed exclusively at period 1. One of the disputes about period 1 was whether the blade damage occurred at times when Duke Energy was operating above nameplate capacity or below nameplate capacity. Mr. Pollich's testimony on that point was that it doesn't matter because when it went above nameplate capacity and then went below, those effects were cumulative during period 1. But there's no basis.
But his testimony was during period 1, the wear was not just on the blades that were replaced, but it was on the unit itself.
He made a reference to general wear and tear on the unit, but he testified that he was unable to identify any damage. Again, this is at page 3401. Mr. Pollich, the other side's witness, testified that he had seen no damage to any steam turbine component other than the L0 blades that could have explained the blade damage while operating within the established parameters.
It's like we've experienced with our vehicles at times where they start making a noise and you take it in and take it in and take it in and they can't find the problem. I mean, that's why the way I read his testimony is that they couldn't identify a specific problem, but the fact that that thing was spinning at a rate that it wasn't designed to spin and ramped down and ramped up over that period of time, period 1, wore the machine to a point that it couldn't operate at its rated capacity without wearing out those blades. I mean, that seems to be his testimony and seems to be what the hearing officer found.
Well, I agree that's what the hearing officer found. I disagree that that was his testimony or that there was evidence of that sort of an effect, a continuing effect beyond period 1 of the steam turbine component.
And let me just jump to your issue 2 really quickly. If that's what the hearing officer found in paragraph 119, then that really is a factual matter. So even though it was stated in a conclusion of law paragraph, the proper review of that would be for competent substantial evidence, correct?
A factual finding, even if contained in something denominated a conclusion of law, is reviewed as a factual finding. Many of the findings that are in the conclusions of law involve, I would say, mixed questions of fact and law. But paragraph 119 in particular appears to rest entirely on the idea that something imprudent happened in period 1 and then something else happened later. And that was really Mr. Pollich's theory and the intervener's theory throughout this case.
Yeah, paragraph 119 cannot be what this case is decided on. I mean, it seems, what I'm curious is it seems like a lot of the questions are going to, they're kind of assuming that the hearing officer made an affirmative finding of a connection between period 1 and what happened in period 5, and we're sort of looking through the record to see if there's support for that finding. The way I read this, though, there wasn't that finding. The ALJ did not affirmatively draw the link between period 1 and period 5. It basically just said, we don't know what the connection is, if any, and DEF didn't. So, I mean, would it be appropriate to send this back and ask for an actual finding on that? And it seems like the answer to that question has to depend part on whether you had the burden to actually prove what the real cause was, or whether the whole point of this is to make the ALJ come up with what is the evidence show is the most likely explanation, and then sort of decide the case based on whatever that affirmative finding is.
So Justice Muniz, I think there's two ways to address it. One would be the way that you suggested and that we requested in a form in our alternative argument, that there be a remand for some reconsideration of the record under the standards here. The other would be just looking at the competent substantial evidence standard, because we would submit that there is simply no competent substantial evidence in the record, not even with Mr. Pollich's testimony, that period 1 caused what happened in period 5. Mr. Polich's theory was that if it weren't for what happened in period 1, those blades would have still been in place, and there would have been no needs for periods 2, 3, and 4, and then ultimately period 5. That theory, though, was the very theory that the ALJ rejected as speculative in paragraph 119. So if that theory...
But it's an inference from the experience with the rest of the fleet, right? I mean, isn't that basically the support for that?
I disagree with that, because I think that the record showed that this plant was different from some of the other plants and had some unique circumstances. I think some of that is addressed in the root cause analysis, that there were some factors specific to the Bartow plant. So what did Duke Energy do after the period 1 outage? Well, it did what a prudent utility manager would do. Talked to the manufacturer. It tried to identify, through a root cause analysis, through trying different operating parameters, how to best operate this plant for the benefit of itself and its customers. And I think that's what led to the prudence determinations in periods 2, 3, 4, and 5, including the installation of the pressure plates in period 5, which was a direct result of responding to the forced outage in an attempt to get the plant operating in a limited capacity. It's exactly what a prudent utility company would do, and the PSC precedent states that utility companies can be prudent in relying on the advice of vendors who have superior expertise in this. If the manufacturer of the plant was giving advice to periods 2, 3, 4, and 5 on how best to configure this plant and operate this plant to produce at the best capacity, Duke Energy was reasonably entitled to rely on that advice, and did so. And ultimately, throughout this period, past period 1 here, record is undisputed that Duke Energy acted prudently. I'd like to reserve the rest of my time for rebuttal.
Thank you. May it please the court, I am Catherine Cowdery, representing the Florida Public Service Commission. The legal landscape of this case does not include any disputed issues of law. It includes DEF arguing application of facts to points of law that are not in dispute and asking the court to re-weigh the evidence. The Commission used the proper standard of 12057 when considering DEF's exceptions and adopting the ALJ's recommended order. DEF's exceptions solely asked the Commission to reject or modify ALJ's legal conclusions, asserting that the ALJ misapplied the legal standard of prudence by applying hindsight, and that the conclusions were contrary to Commission policy. Those were its two arguments. The plain language of the final order shows that the Commission agreed with the ALJ's conclusions of law. Contrary to DEF's assertions, because the Commission rejected the ALJ's legal conclusions, there was no 12057 requirement for the Commission to analyze whether the ALJ's legal conclusions should be modified with a legal conclusion the DEF was asserting was as or more reasonable. The Commission did not need to state with particularity its reasons for rejecting or modifying the ALJ's conclusions of law, nor make a finding that its substituted conclusion of law is as or more reasonable than that which was rejected or modified.
Would you agree that the ALJ's conclusions of law either state or assume causation, that the imprudent actions prior to 2012 caused the problems in 2017?
I think the ALJ in his recommended order shows us what he relied on for causation. He had a very specific, detailed section on the findings of fact, and in fact, of course, the conclusions of law contain finding of fact as well. And looking at that, we see what evidence he relied on for causation, which included the Mitsubishi and DEF root cause analyses, especially looking at, I think...
Okay, so when Duke filed its exceptions to the conclusions of law, I read that as taking exception to the finding of causation. And I think the Commission did as well, which is why you use the competent substantial evidence standard of review, correct?
I think the reason that the commission addressed competent substantial evidence, there were two reasons. One is as part of DEF's argument that there were legal reasons for rejecting the ALJ's conclusion, it brought in as support some of its evidence. Okay? And so the commission, whether or not there had been exceptions filed, it would have been reviewing this recommended order under 12057. And it would have looked at competent substantial evidence.
So in the commission's view, what is the competent substantial evidence that supports the causal finding?
Well, that would be going back to the recommended order, the Mitsubishi and DEF root cause analyses, and those findings of fact in that particular section. And that is possibly Exhibit 115 were the working documents, I think looking specifically at that finding of fact 71. Also, the testimony of Richard Pollack.
Can you tell me exactly where in the order this causal finding is?
I think there's nothing specific that I can remember where they specifically talk about causation, and I think...
So, I mean, the beginning of this thing is like a glorified bench memo. It's party A said this, party B said that, witness C said this. Then we get to the actual thing where the ALJ is actually doing the work, and we get to this inscrutable paragraph 119. I don't see any causal finding there, and then when he closes the loop, he basically just says, we have no idea how we explain what happened between periods 2 and 5, but DEF didn't prove that it wasn't because of period 1. So,
okay.
I mean, what I just want to be clear, what is your best answer on where the causal finding is?
I've got two things I want to address, because I also want to say I think you are correct about burden of proof is very important in this case. Utility always has the burden of proof of showing its entitlement to recovering costs that are then passed on to the consumer. So some of your comments before to the appellant, I think, were correct. They were fair. That there was a lot of conflicting evidence here, and the ALJ had to weigh it. And ultimately, the burden of proof was on the utility. Then going back to causation, I think we're looking at Pollack's testimony.
No, I'm from the ALJ. I'm not asking.
Oh.
We can't assume that there was a causal finding and then look for the evidence. I mean, so step one is, where is the causal finding in the order? And only once you've established that do you then get to sort of go through the record and see if there's evidence to support that finding. So where is the finding?
I'm not sure.
So let me ask you.
Agree with that.
So looking at paragraph 119, it reads, "It's speculative to state that the original period blades would still be operating today, but had DEF Duke observed the design limits of the 420 megawatts." So that's not the finding. It is not speculative to state that the events of periods 2 through 5 were precipitated by DEF's actions during period 1.
Right.
Isn't that I read that as a finding of causation. Does the commission view it that way?
No, I agree with that. And I believe that that's what that's where you go back and you look at the recommended order to find where did he get that. And I think he lays it out for us.
No, but I mean, that's
in
to
detail.
say, to say in this vague way that the events of periods 2 through 5 were precipitated. There's a lot that happened in periods 2 through 5. That is not the same thing as saying that. Isn't the question here whether the need to get the replacement power and going offline and everything was caused by the period 1 improvements? I mean, that seems like a much more sort of precise thing than to just say the events were precipitated. I mean, no one disputes that a problem emerged at the end of period 1,
Right.
that there was all these things were done to try to then fix it.
Right.
It's
And
possible, It's possible that, right at the beginning, once they started, once they did whatever they did at the beginning of period 2, that they had, fixed. I mean, we don't know, and all I'm saying is that this, and I don't know, maybe the ALJ in his mind thought that causation had been proven. I mean, he does repeatedly rely on the burden of proof to him. I just don't know.
I think
And then in this paragraph here, it ends with saying, but it is possible to state that events would not have been the same. I mean, what is that?
Right. But I do believe that there is competent substantial evidence that he points to in the recommended order that show that were it not for running the plant over 420 megawatts during period 1, you would not have had this cascading series of events that caused the replacement power costs that have to be passed on. And I'd like to leave a little time for the Office of Public Counsel.
Well, they're actually going to have 10 minutes, so.
Oh, okay. Time remaining is just mine. Got it. Okay.
So, looking at paragraph 119 in the part that I read, it necessarily has to be given the conclusion that the hearing officer either concluded causation with that somewhat cryptic sentence, or that he concluded that Duke had not met its burden of proof with respect to the issue such that they were not entitled to, I mean, it has to be one or the other, right?
Well, I think it can be both. That there was causation and they hadn't met their burden of proof.
Okay.
And I think that's what we find in this case.
So is it your position then that does the proof work sort of holistically at kind of everything that happened between the emergence of the problem and when the ultimate outage happened? Because it's sort of, one thing that's sort of weird about this is that it's been sort of sliced up into all these different periods. But, in some sense, and I don't know if this is a legal question or a factual question, if you look at the way this entire thing evolved over the period of all this time, I mean, no one can dispute that their response to the problem when the problem was identified in 2012, seems like everything that they did afterward was the essence of prudence, from what I can tell. So are we supposed to just sort of say that essentially there's nothing that they could do after 2012 that would have, maybe they could have made it worse.
Well, and I think there was some testimony from Richard Pollack that some of the things that the manufacturer had done during that time period, in his opinion, did make it worse.
Right, but that's not DEF's. And no one is attributing any problem to what
Correct.
DEF did after.
Right. The cutting the time period down into different periods was simply a construct that DEF did as part of its root cause analysis, that every time that there was a shutdown, either planned or not planned, that became a period. But that is the only significance it has. It doesn't have a significance as far as the Public Service Commission, in its responsibility under Chapter 366, can only approve as costs to be passed on to the customers prudently incurred costs. And as its responsibility in this case, where it had an ALJ's recommended order to review, it had to follow 12057. And it found that there was no legal basis for overturning the ALJ's decision, and that there was competent substantial evidence supporting the findings of fact. The conclusions of law were supported by findings of fact supported by competent substantial evidence, and it properly followed 120.
Counsel, you're now well over.
Thank you.
May it please the Court, my name is Anastasia Perello, and I represent the joint appellee, the customers of Duke Energy Florida, by and through the Florida Office of Public Counsel. I'd like to start by addressing this competent substantial evidence argument that we've been getting into. To your question, Justice Lawson, I agree with Ms. Cowdery. The finding is both that Duke did not meet their burden of proof, which is based on the rejection of their expert's testimony, Jeff Schwartz. Judge Stevenson said that it was unclear how he reached certain conclusions, that his testimony was unpersuasive, and that he was unable to explain away certain criticisms, and that was their burden to meet. However, in paragraph 114, Judge Stevenson also stated that to the contrary, the preponderance of the evidence pointed to Duke's operation of the turbine in period 1 as the most plausible culprit. And all of this evidence is overwhelming. It's Duke's root cause analysis, which is stated in paragraph 71, in which their own experts stated that their actions in period 1 were one of the most significant contributing factors toward blade failure over the history of the turbine. It's also Mitsubishi's root cause analysis, which is restated in paragraph 62 and 71, which is also supports the concept that Duke is at fault for the outage.
If the evidence was so overwhelming, it seems like not too hard to expect an affidavit from the engineer that said, in my professional opinion, what happened in period 1 caused this. That's not really in the record, is it?
In Duke's root cause analysis, their own engineers did explicitly draw that line and say that their actions in period 1 caused the outage in period 5. And to address the comment that Mr. Polich disclaimed that causation, there's a larger context to that cross statement, which the transcripts of that hearing are confidential. However, the context is that he did not conduct his own root cause analysis. He reviewed Duke and Mitsubishi's root cause analyses, and based on those, he found that the damage was likely to have been cumulative, and that but for Duke's actions in period 1, we wouldn't have been here today. There's also abundant evidence.
So the specific language that you're talking about is summarized in paragraph 62 and 71?
That's Mitsubishi's root cause analysis, yes. There's also abundant evidence about what happened elsewhere, as we discussed, which also supports the finding that Duke was at fault for this outage. And Judge Stevenson stated that it would have been simple prudence for Duke to have consulted Mitsubishi prior to operating the turbine in a manner which Mitsubishi did not anticipate and which Duke knew or should have known was beyond the design point of the turbine. Mitsubishi never wavered from their conclusions in all of the periods that followed period 1. All of this evidence demonstrates that not only was Duke imprudent in period 1, but that this imprudence flowed through and was the consequence of the period 5 outage.
You view the paragraphs 114 and 119 consistent in the sense that paragraph 114 is talking about the period 1 negligence as being the most likely culprit, but then it says in paragraph 119 it's speculative to state that the period blades would still be operating, has the thing about the events happening, but then it says it's not possible to state what would have happened. I mean, it sounds like he's saying two different things in those paragraphs.
Judge Stevenson was stating that it is not possible to predict an alternate future. However, but for Duke's actions, which precipitated the outage, there would not have been periods 2 through 5, and there never would have been the outage in period 5.
What is a court supposed to do when you have kind of an incoherent order?
We agree the language is imprecise. However, Duke did not take exception to any of these findings of fact at the commission level, and we would argue that that argument has been waived. Nevertheless, the evidence is overwhelming, even if the statement is slightly unclear.
Well, I don't think the ALJ thought that the evidence was overwhelming, or he wouldn't have emphasized the thing so much at the end. He would have affirmatively talked about the causation going the other way.
Well, causation is an element that is embedded within the burden of proof that the utility must demonstrate that their actions did not cause or significantly contribute to the outage. And again, we have their own engineers saying that they significantly contributed. The second point that I'd like to address briefly is the standard that the Commission used in reviewing the exceptions to the conclusions of law. As Ms. Cowdery stated, the statute states that an agency may reject a conclusion of law, and that if they do so, they must state their reasoning with particularity and make a finding that the substituted conclusion was as or more reasonable than those of the administrative law judge. The Commission did not do this, however. They adopted the recommended order without modification and resolutely rejected all of Duke's exceptions. And they did this with a full and complete understanding of their powers under this statute. Nothing demonstrates that better than the statements of Commissioner Fay, an attorney, during the hearing on the exceptions, in which he stated that he did not want the refusal to take the exceptions of Duke to be construed as a misunderstanding of their powers under the statute, stating explicitly, I think it's very clear we have the authority to do that. Duke now attempts to flip this standard on its head and suggest that the Commission was required to accept any conclusion of law that was as or more reasonable. And this is simply not the standard. The Commission went beyond what the statute required and did make a finding that each exception was not as or more reasonable and explain that reasoning, but the statute did not require them to do that. And accordingly, Duke has not demonstrated that the agency's decision is based on any finding of fact that is not supported by competent and substantial evidence, or that the Commission erroneously interpreted a provision of law and therefore has failed to state a basis for remand under 12068. And we would request that this court affirm the Public Service Commission's order.
Few brief points in rebuttal. First, to Justice Kennedy, a more complete answer to your question earlier. The specific portions of the record that demonstrate what happened here, we addressed them at pages 31 to 32 of our brief, and the record citations to the confidential portions there, including Joint Exhibit 82, page 12 of 35. I acknowledge that competent substantial evidence is a high burden in a case like this. So I want to talk about a couple portions of the record where the other side's witness proves our case, in our view, and direct you to those specific parts. The first is one that I discussed earlier. Mr. Polich, the intervener's expert, explicitly disclaimed a causal relationship in his testimony at page 3405 of the record, a causal relationship between period 1 imprudence and the period 5 outage. Mr. Polich admitted that he would be speculating for any other factual basis for the period 5 imprudence. That's at pages 3398 to 3399 of the record. Mr. Polich's theory was that there was imprudence in period 1, and everything after that came after period 1, and therefore was a result of period 1. That's not a causal relationship, and that's not enough. I disagree with my friend on the other side's characterization of the DEF working papers. They were exploring after the fact potential causes of what had happened in period 1. I disagree that they had made a causal conclusion of their own adverse to DEF. And even the PSC's final order here seemed to acknowledge that there was a problem with the way the ALJ approached the prudence analysis. The PSC announced that its final order here was of, quote, limited precedential value, and that it was not adopting any policy that it would be imprudent for a public utility to run a unit above nameplate capacity. That's completely irreconcilable with the ALJ's conclusions, even as to period 1. And Commissioner Pullman's dissenting opinion in the final order, I think, accurately characterizes the nature of what the PSC did with the order that it was presented from the ALJ. In conclusion, my friends on the other side have stated that we're asking this court to reweigh the evidence. We're not doing that. It requires no reweighing of the evidence for this court to observe that one side of the evidentiary scales on causation is entirely empty. There's simply nothing there. So for the reasons stated in our briefs, and unless the court has further questions, we'd ask the court to remand to the PSC either for entry of an order in favor of Duke Energy or for reevaluation of the ALJ's recommended order under the correct legal standards.
So do you read this order as making a causation finding?
Are you referring to the recommended
I'm sorry,
order?
the recommended order.
I don't. I read the ALJ's order as implying causation through temporal sequence. We identified below and in our briefs the logical fallacy there of saying since it came after, it must have been caused by it. I don't see anything in the ALJ's order that does more than that on causation. There was period 1 imprudence. It's speculative in paragraph 119. It's speculative to say if the blades from period 1 hadn't been damaged, if they'd still be there or not, but things would not have been the same. That's simply not an adequate finding of causation in order to support a finding of imprudence here.
And can we hear your answer as to whether paragraph 114 is a finding of causation?
You sure I'm looking at exactly the paragraph you're referring to there?
Your colleagues on the other side sort of pointed us to, and we discussed, the relationship between paragraphs 114 and 119, which are in some ways in tension, and in other ways you might say 114 comes closer to making a conclusion about causation. And I guess my question is, if 119 doesn't supply that finding of causation, does 114 do it?
I don't think so, Justice Curiel. I think 114 is talking about period 1 issues. It's period 114, and I have the unconfidential copy here, so I want to be careful in the way that I discuss this. The discussions in the first sentence of paragraph 114 and the conditions that it describes there were exclusively present during period 1 and were not present during period 5. So I don't think paragraph 114 or 119 provides that requisite causal link. Thank you very much.
We thank both sides for your arguments in this case today. The court will now stand in recess before we take up our next case, and we'll be out for about 10 minutes.
All rise. Supreme Court of Florida is now in session. Please be seated.
The court will now take up the case of the state of Florida versus Johnson. Counsel?
Good morning. May it please the court, my name is Damaris Reynolds, and I represent the state of Florida in this case. We are here today because the district courts of appeal have ignored the plain language of section 316.027(2)A, and they have determined that the unit of prosecution for leaving the scene of a crash without rendering aid to each victim of the crash is the crash scene rather than the individual victims. Now, when we look at the text of section 316.027(2)A, it states that a driver shall remain at the scene of the crash until having fulfilled the requirements of section 316.062. So it says shall, it's not optional. And then when we look at text 316.062, when we look at the text of that section, it also uses the word shall. And it says that the driver shall render to any person injured in the crash reasonable assistance by making arrangements for such person to receive medical treatment if it appears to be necessary or when the injured person requests it.
Let me pause you there. So just as a thought exercise, obviously a prudent way to render such assistance to everyone injured in a crash, pick up the phone, call 911. But let's assume that there are 15 people injured in one episode, one crash, say in 8 different cars. Would it be the state's position that the defendant would be chargeable with 14 counts of a violation of the statute if he devoted his exclusive attention to one victim?
So the duty is to each victim. And so, of course, that's a very fact-specific question, and that would be a question for the jury. Did this driver do everything that he or she could for the victims?
Well, but before we get to
the
jury, I'm focused on what the unit of prosecution is.
Absolutely.
It seems to me that one logical consequence of the state's position is that the state could charge that individual with 14 counts of violating the statute if that individual focused his attention on just one. Perhaps the state, in exercise of its prosecutorial discretion, wouldn't charge that person, but with 14 or 12, 10 or 5 counts. But it seems to me for your position to fit together logically, the statute must permit the state the ability to charge the defendant with every person who the defendant doesn't render aid to. Do you disagree? Am I reading this wrong?
No, I do agree.
Okay.
And that is the state's position.
No, let me interrupt you on that, though. This isn't about failure to aid for someone who's there. I mean, so this hypothetical really isn't this case, because until you leave, if you focused on one and then left 14 unaided, then you would maybe have the 14. But if you're just there and you're focusing on one and you're not aiding someone, you maybe have potentially violated the 316.0271, but that would, you get into whether it's reasonable, but that itself is a non-criminal traffic infraction. And so there's no crime, whether it's to 15 people or 1 person or 8 people, as long as you're still there.
No, there is the crime. You have to be there and you have to render aid.
No, it says the crime is to leave before you have fulfilled the obligations.
Correct.
So until you leave, you have not committed a crime.
If you don't leave the victims without rendering aid, you have not committed the crime. But if you do not render aid, you are committing a crime. And the problem with the hypothetical is that, you've got an accident, all right? Normally you have bystanders. Here you are, there's an accident, and so you can certainly, someone's bleeding out, you're putting pressure on their wound. You can yell to bystanders, help the other people, help this other person, and that's how you fulfill your obligation. Because, you're trying to make arrangements, which is what the statute requires. You're trying to make arrangements for all of the victims to receive medical care.
So, counsel, I just want to be abundantly clear so that we understand what you're asking this court, the state is asking the court here. Are you asking this court to determine that if a person, which did not happen in this case, I mean, I think it's undisputed that he left the scene. But if someone stops and remains at the scene, but does not render aid to every person that they have committed a violation, a criminal violation, a felony.
They have to stay at the scene and render aid. Now, how you define rendering aid, they'd have to make medical arrangements.
Let me ask the case that's not an issue in this case, because the guy left.
Correct.
So this is all a hypothetical
Correct.
about what might have
This
happened.
is absolutely,
and
they're
is
both
the state really
hypotheticals.
interested in that? That's not what you're really interested in,
Well,
is it?
no. What the state is interested in is the text of the statute and asking the courts to follow the text of the statute. I mean, in Dumas, this court said in 1997 that Florida law imposes an affirmative duty on a driver to stop, render aid, and provide certain information whenever there is an injury. This court already said that in 1997. And what happened was in 1998, the 4th DCA in Hardy decided to follow Hogue, which was a 1987 case, rather than following what Dumas said. So it's already established that Florida law imposes an affirmative duty on a driver to stop, render aid, and provide certain information whenever there is an injury. And so the state's position is that the statute should be followed. The text of the statute says what it says. It uses the word shall. And so we need to follow what the statute says. It says in 2A, 316.0272A, shall remain at the scene of the crash until he or she has fulfilled the requirements of 316.062. 316.062 goes really very specifically into what it's required. It says, shall render to any person injured in the crash reasonable assistance. So it's reasonable assistance. It's reasonable assistance. I mean, obviously, you're not going to be able to save every person in a crash, but you have to render reasonable assistance.
I think Justice Labarga has a question for you.
That's
You'll
all
give him a
right.
chance.
Go ahead and finish.
Okay. I'm sorry. Sometimes I speak a little fast. But the reasonable assistance, you agree? The reasonable assistance includes the carrying or the making of arrangements for the carrying of such person.
There. Thank you. Let me see if I can get it straight. The issue in my mind here is this unit of prosecution situation, right?
Yes.
That's what we're talking about?
Yes, sir.
Okay. Now, is the unit in your mind, and what I'm trying to hear from you is it the unit of prosecution is one case per scene, or is it one case per victim?
It is one case for a victim, and I'll give you an analogy, okay?
Well, that's what we're talking about here, right?
Yes,
the issue.
that's
right.
the issue.
And we know we had to stop,
Yes.
and we know we have to render aid.
Absolutely.
The question is, when there are more than one person injured,
Correct.
are there 5 counts, or is there 1 count just for not stopping?
Right, so it's not just one count, and I'll give an
Well, where do you get that from?
Okay, well, from a plain reading of the text.
Well, you've been saying that. Read it to me. Let me
Okay.
hear you say it.
So it says in 2A, the driver of a vehicle involved in a crash occurring on public or private property which results in injury to a person. So it is talking about injury to a person. It's talking about each person. And it says, shall remain at the scene of the crash. So shall remain at the scene until fulfilling the requirements of 316.062. Now, 316.062 says, shall render to any person injured in the crash reasonable assistance, including the carrying or the making of arrangements for the carrying of such person to the physician, surgeon, or hospital for medical or surgical treatment, if it is apparent that treatment is necessary, or if such carrying is requested by the injured person. So everywhere in the statute, it uses the words shall. The requirements have to be met, and then it specifically states what those requirements are for each injured person.
Well, I mean, the word shall, it applies to you have to stop. You can't leave. But the question is in the unit of prosecution, what I'm thinking of here is whether that means that if you leave, you are guilty of not rendering aid to each person injured or killed.
It doesn't just say shall remain. It says shall render to any person injured in the crash reasonable assistance.
Right.
That is part of the statute too. So we can't stop at the part where it says that shall stop. Or shall remain at the scene, shall provide information. We also have to read the part that says shall render to any person injured in the crash reasonable assistance.
I think you're.
No, I was just going to say, couldn't we read 316.027.2a as essentially saying you must stop, you must remain, and how long you remain is related to 316.062. So that gives kind of a time frame for how long you stay at the scene. but not fulfilling the requirements of 316.062 is not part of this crime. So for instance, if I am in an accident, I stop, I remain until everything is taken care of, but I refuse to give my paperwork. Have I committed a violation of this criminal statute?
No, that would be a violation of 316.062, which is titled Duty to Provide Information and Render Aid.
Okay. So how does this particular section, not rendering aid, where are you getting that part?
Okay, so we cannot remove the reference to 316.062 from 316.027. I mean, it's in there, and we can't take it out, and that's the defense position, that, you know, we should ignore the reference to 316.062,
Well,
and
we're not talking about
somehow,
ignoring it. I think we were talking about how it affects or whether it affects the unit of prosecution. So back to Justice Grosshand's question, hypothetically, if an individual is involved in a traffic accident and there's one other car with two people in it and they remain there until law enforcement comes, paramedics come, whatever, the whole thing's over, they exchange their information, but they don't render aid, is there a violation of 316.027?
there
Two
is.
violations.
Yes, there is.
But they
there
remain.
are, because, again, 316.027.2 requires the fulfillment of the requirements of 316.062, which says, shall render to any person injured in the crash reasonable assistance.
So we know it would be a violation of 316, but what 062, but what 027 says is that they shall remain until they fulfilled the obligations.
Right. Well,
So if they remain until the scene is done,
have they fulfilled the obligations?
but they didn't render any aid,
Then arguably they did not fulfill the obligations, because the obligation is there. Shall render to any person injured in the crash reasonable assistance.
Yeah, I don't think you're helping yourself by focusing on this hypothetical remains and what they have to do. I mean, in 062, it says a violation of this section is a non-criminal traffic infraction punishable as a non-moving violation, provided in chapter. I mean, you're getting into this weird thing where you're creating a potential kind of conflict between the two statutes. I mean, what we're here to decide is for the person who leaves, and
That's
whether
correct.
you count the unit of prosecution by victim or by crash scene. So it just doesn't seem like there's any benefit to you or to the court to be speculating about what someone has to do who doesn't leave.
That's correct, absolutely, because we are talking about charges against people who did leave the scene of the crash. I mean, and that's really what we're talking about. We've got charges for someone who did leave the scene of the crash, and, you know, so there was one person who was dead and 3 people who were injured, and that would be very much like, for instance, detonating a bomb. You know, that's one act, to detonate a bomb. But then, you know, 1 person is killed and 3 are injured. There's going to be 4 victims. There's going to be 4 charges. I mean, so this is the same issue. You know, you have one act that's been committed, but it has resulted in, well, one act in the sense that there's a crash, but 4 acts in the sense that 4 people have been abandoned at the scene without rendering them aid.
But the crash itself is what caused not the leaving, is what caused the injuries to each individual victim. I mean, detonating the bomb kills each person, so arguably you would charge that separately. But here it's not the person leaving the scene that causes the injury and death, it was the accident itself.
Well, not necessarily. I mean, leaving the scene can result in a death that otherwise would not have happened. You know, some time ago in Palm Beach County, Goodman.
Well, that's the point of the law, isn't it?
Yes, that is the point of the law. That is the
Because
point
it can make a difference.
Absolutely. I mean, there was a gentleman named Goodman, I think, the air conditioning company, Goodman, and he hit someone in Wellington. It was, I believe it was a UCF student, 23 years old, and left them to die there in the canal. And, you know, went home or went to a friend's home to have a drink. You know, so you know. The law is there to protect. You know, the driver who creates a peril has a duty to act to address the peril that he has created. That's what the statute is about.
On that point, this applies to a driver who is totally innocent.
Yes.
It doesn't mean that the driver had to create the peril. The driver might have been the victim of someone else's negligence, and they'd still are covered by this.
Yes, in this particular case, the driver did create the peril. We're not talking about a driver who, was involved in, or was a bystander, or, was involved in the crash, but was not injured, and, that's not the situation that we're facing in this particular case. So again, I think it's very important to look at this text of the statute and read exactly.
Counsel, I will tell you, you're now moving into your rebuttal time.
Oh, I'm sorry. Okay.
I mean, you can keep going, but you're consuming your time.
Well, I'll just say this for now. Because the district court's analysis of the statute has been faulty and incomplete, and a conviction per victim does not violate double jeopardy, this court should answer the certified question in the negative and reverse.
May it please the court, Glenn Gifford from the Second Circuit Public Defender's Office on behalf of Mr. Johnson. I'd like to ask the court's indulgence to discuss jurisdiction for a moment before I move on to the merits. The certified question asks about the consideration of two statutes in tandem. It says, given the requirements of 316.062, and then it goes on to say, what does 316.027 require? The majority opinion doesn't talk about 316.027 at all. Only the concurring opinion does. And so that's in the certified question. It's not in the decision that the district court has passed upon or ruled upon in this case. In fact, even the opinions discussed in the majority opinion and the concurrent consideration in the law, courtesy of the concurring opinion below, whether 316.062 has any effect whatsoever on how you construe this statute for purposes of the unit of prosecution. It's kind of like per curiam affirmance with citations, although here it's a reversal following 30 years of case law. This court doesn't have jurisdiction to review a PCA, even when there's a certified question, if the court has not passed upon the question certified. It did not hear. The district court did not hear. Moving on to the merits, it seems that both parties are seeking the high ground of plain meaning. And to understand who gets the high ground, I think you have to look at this case, this statute, 316.027, in comparison to the vehicular homicide statute. It's different language. Here, the language is must stop and remain until the requirements of 316.062 are met. The vehicular homicide statute says that the defendant must give information and render aid as required by 316.062. The difference are the active verbs give information and render aid in the vehicular homicide statute. Here it is stop and remain, and then it creates conditions under which a driver who may or may not have been the cause of the accident may leave.
So on that, to sort of go to the obverse of the fact scenario we were discussing with your colleague on the other side, is your position that in a crash involving multiple victims, if a defendant stops and remains and attends to one victim, but then leaves, that because it's just one crash, that defendant is immunized from prosecution in the case of the other victims because he stopped and remained at the scene of the crash for one victim and solved whatever physical injury there was? Is that because the unit of prosecution under your lights would be a crash, is he then immunized from prosecution?
Well, not immunized. The unit of prosecution is the one crash, the one leaving, the one failure to render aid in this instance. So yes, regardless of how many persons are injured in the crash, yes, it's the unit of prosecution is one because there's only one crash. The unit is one crash, not one person injured who hasn't been.
So in that case, could he be charged or not? I'm not sure I understand your answer.
He could not be convicted of multiple offenses because the unit of prosecution is one crash.
Okay. So your version of your plain meaning of the statute says that if I leave the scene and don't render aid to victims 2 through 15, as long as I did it for victim number 1, this statute says I cannot be charged with a felony.
No, I believe that there could be one charge under those circumstances, but only one.
One count as to victims 2 through 15.
As to any victims that were not offered aid, that if the defendant does leave.
Okay. And that's because you view it as one duty as a whole. So you've either completely complied with the duty or you have not.
Well, there isn't a duty to render aid under this statute. There is a duty to remain.
There's a duty not to leave without complying with 3.06.
That merely sets
right?
the conditions under
and
which you may
haven't
leave.
complied with 3.062 until you've helped every reasonably assisted every victim.
That's right. But if you remain and don't do anything, then under the plain
But
language.
we don't need to. I mean, I think. Do you want to make this case about that? I mean, what does that hypothetical have to do with it?
It doesn't have much to do with this case, but it doesn't really matter because in double jeopardy issues, you don't look at individual cases. Even for unit of prosecution, you look at the statutes, you look at the charging document, and you don't look at individual cases and individual scenarios.
Okay, so let's talk about what the case is about, which is, can you explain why the evolution of the statute from 1987, when it seems like sort of the Fountainhead case here was decided, which has been arguably kind of without too much thought going into it, relied on subsequently. It seems like the evolution of the wording of the statute has tended in the direction of making it more focused on specific individual victims and less on the crash scene.
No, I don't think the statute has evolved at all. I think the statute's been pretty much the same.
Well, no, I mean, that's factually wrong. I mean, what inferences we draw from that? I mean, the statute in 1987 read, the driver of any vehicle involved in an accident resulting in injury or death of any person shall immediately stop, et cetera, et cetera. So it has moved from that to, if a person suffers one type of injury, then the second thing is a mutually exclusive type, and then the third is death, which is mutually exclusive. So it seems like the evolution of the statute has pointed more toward an individual victim specific view.
It has separated out slight injury, serious injury, and death. But aside from that, the key language of the statute, stop and remain until satisfying the requirements of 316.062, has not changed.
The key language, the 1995 statute, which is the one that the 4th DCA relied on, uses the words resulting in the death of any person. But then the 2020 statute says which results in injury to a person. Now that seems like a drastic change in wording.
My understanding is that
isn't that agreement to what Justice Muñiz is saying, that the statute has moved more in the direction of making more accountability for each person injured?
That's correct, Your Honor. But the serious injury and injury are lesser offenses of death, and so it all gets collected up into double jeopardy that way. And
are they really though? When they're in this case, the way the statute writes it in a way that each category is mutually exclusive. So the first category says injury other than serious bodily injury. So it doesn't say injury, then serious bodily injury, then death. I mean, they specifically have drawn a circle around each thing so that you have to fit each injured into one box or the other.
yes, Your Honor. But our position is that the key language for each of those provisions is stop and remain until. And that's what you look at to determine the unit of prosecution, because there is no obligation if you remain. There is no crime, let me put it this way, if you remain without providing aid.
How do you address the argument about the restitution provision, where it seems to say that each violation of the statute results in the victim, meaning, a singular victim?
Well, if we're correct about the plain meaning of the language that I'm talking about, the restitution statute doesn't change that. But also...
But why? I mean, it would assume that there's only, every crash just involves one victim.
Well, in addition to that, it would not be necessary to specify restitution to each victim if the unit of prosecution was each person injured. You could look at it that way. that the necessity of requiring restitution to each person is only in there because the unit of prosecution is one crash regardless of how many people were injured.
But the double jeopardy argument, clearly, if more than one person is killed in a single accident, they say there are 4 people in the car and it rolls over and people are killed, you can charge a vehicular homicide as to each person who died, couldn't you?
Yes,
in that
absolutely.
one single accident?
You could, Your Honor. That's
so
correct.
Why couldn't you charge leaving the scene of an accident as to each of the people who were injured in that single accident?
Well, that really gets to the core of our argument, which is the difference between the vehicular homicide statute, which requires that you give information and render aid as required by 316.062, and this statute, which says that you stop and remain until you satisfy the requirements of that statute. And to really understand that difference, I think you have to look
But
at
it's to satisfy the requirements of the statute with respect to each person, isn't it? I mean,
well,
isn't the statute aimed at trying to protect each of those persons and to ensure that aid is provided to them as it can be in the circumstances through the actions of a person who was involved in the accident?
If you filter this statute through 316.062, that's correct. But even if you have a single unit of prosecution, then you can still be charged with a non-criminal traffic infraction under 316.062 for each person injured that you did not assist. And the problem goes beyond that, and that is that 316.062, it has 3 requirements. It's give information to anyone injured, it's give information to the police, and then it's render assistance, including medical assistance, to anyone who is injured. If the unit of prosecution is each person injured, then a defendant could render aid to each person injured, but not give the information to either the police or each person injured, has not, and these are in the conjunctive. So you will have violated 316.062, and because we don't look at individual facts, you have multiple prosecutions, multiple convictions for each person injured, even though you've rendered aid, because you haven't complied with this information part of the statute. And
when did this accident happen? What was the year?
Excuse me?
What year did this accident happen?
2016? 2016, Your Honor.
So we're operating under the 1987 statute? No, which statute? The rate reached now, the 20.
Well, as to the language that we're focusing on for plain meaning, yes.
Because the way it reads now, injury to a person. They use that phrase over and over again. Injury to a person.
It does say that, Your Honor. And if it were otherwise ambiguous, you only go to the any test if it's
well, it doesn't
ambiguous.
say injury to each person. It says injury to a person.
And in other places it says to any person. So if you conclude there's an ambiguity, then under the rule of lenity, the unit of prosecution is one crash and not each person who is injured. And if I may, I'd like to discuss for a moment the McKnight case, which is the Fifth District Court of Appeal case from 2005. And in McKnight, the court interpreted the vehicular homicide statute to authorize multiple convictions enhanced to a first-degree felony for failure to render aid. And the court noted that in 1996, the legislature amended that statute to clarify that the aspect of criminal conduct to be punished under that provision is the defendant's failure to render aid to each victim of the accident as required by 316.062, rather than the defendant's act of fleeing from a single accident scene in violation of 316.027. So I see that as distinguishing the language of the vehicular homicide statute. By the way, the DUI manslaughter statute also has an enhancement for failure to render aid that tracks the vehicular homicide statute, distinguishing that from the language in the failure to render in the leaving the scene statute. And the reason why the legislature might choose to have only a single unit of prosecution per crash is because, unlike for vehicular homicide, unlike for DUI manslaughter, the defendant need not have caused the accident. The defendant need not have driven recklessly, resulting in a death, or driven drunk, resulting in a death. So the defendant, the legislature could reasonably have concluded that the unit of prosecution is per crash, not per person injured. And the McKnight case illustrates the difference between the two statutes. And by the way, it's not just the 3 or 4 cases that have been cited in the majority opinion below and in the dissent. There's an unbroken line of cases going back at least to 1987. I found at least 10 that you might have to overturn or disapprove to adopt the state's construction here.
But the statute's changed during that period of time.
It has changed.
In ways that at least are arguably quite material.
Quite material, but do not change the plain meaning of the active verbs,
That's your position, but
which we think creates the unit of prosecution. I understand, Your Honor.
Counsel, let me go back to the argument you started out with, just to be clear about your jurisdictional argument. Am I correct in understanding that you would think that we have jurisdiction if the first phrase of the certified question had been omitted? So instead of having given the requirements of section 316.061 Florida statutes, does conviction, and so on, that everything before does conviction was removed, that we would have jurisdiction. It's the reference to 316.0621 that you think actually divests us of jurisdiction.
Yes, Your Honor. If it had been phrased simply as, is it double jeopardy to convict someone for each person injured under the leaving the scene statute, yeah, that would be adequate. No, to me it is the influence
They said too much.
316, yes, that's right. 316.062 that creates the problem, according to Judge Winokur, not according to the majority, which didn't even see fit to address 316.062, not according to any of the other courts that have wrestled with this issue, decided this issue over the course of more than 30 years. And as I say, I found 10 cases. I think there may be more. So unless the court has further questions, I ask that you discharge jurisdiction as improvidently granted. If you choose to retain the case, ask that you decide the issue, the certified question, in the affirmative, answer it in the affirmative. It is a double jeopardy violation under these circumstances, and approve the decision of the district court.
Bottom.
So it's the state's position that 316.062 cannot be removed from 316.0272A. It's part and parcel of that statute. They needs to be read. It cannot be divorced from 316.0272A. There's no removing it.
Well, I think the council's point isn't that should be removed. It's that the district court didn't focus on that at all. They didn't.
Right, but this court did back in 1997 in Dumas when it found that Florida law imposes an affirmative duty on a driver, to stop, render aid, and provide certain information, and said that it is apparent the purpose of 316.027 and 316.062 is to assure that any injured person is rendered aid and that all pertinent info is exchanged. And also, as this court noted, back in 2014, the word any was changed in the statute so that the driver of a vehicle involved in a crash that results in injury to a person shall remain at the scene. So it says a person. Right off the get-go, 316.027 starts off with a vehicle and a person. Any was eliminated. And furthermore, this court found last year in Masonette versus Maldonado that defendants must be charged with every offense that arises from one criminal episode pursuant to 775.0214A. And that's consistent with the fact that each victim has a civil cause of action against the driver who is responsible for the crash. This court found that it's the text of the statute, not the facts of the crime, that are relevant for the double jeopardy analysis. And the double jeopardy analysis must look only to the statutory elements. Whoever commits an act or acts which constitute one or more separate criminal offenses shall be sentenced separately for each offense per 775.0214A. The statutory language is the only factor for determining whether the legislature intended to punish separate offenses. The legislature has made it clear in Section 4B that its intent is to convict and sentence for each offense committed in the course of one single episode. And that does not constitute a violation of double jeopardy. So again, because the district court's analysis has been faulty and incomplete, and a conviction for each victim does not constitute double jeopardy, the state would ask the court to answer the certified question in the negative and reverse. Thank you.
All right. We thank you both for your arguments in this case. That's the final case on the docket today. So court is now adjourned.
All rise.